I was never in Houston.
I'm going to grant the motion to reduce the bond. I'm going to reduce the bond in 2060 CCR 0399 to $1 million. Okay, and is that in both cases? Or just the
and the newly
the new-
indicted case.
We have
Right.
a set bond, I believe, in the,
we have already
we have not.
Have not. And so.
in the murder or in the MTRP?
In the MTRP.
MTRP, and so I don't know if that's going to be.
Is entitled to a bond in that one because it's a deferred. And then a bond should have already been set in the murder.
All right, so you're Thaddius McCrae.
Yes, ma'am.
And so, Mr. McCrae, in clause number 21-38959, has a motion to revoke his probation, the underlying offense of aggravated assault causing serious bodily injury. And then we have clause number 26 BCCR 0399, which is the new indictment charging Mr. McCrae with the offense of murder. Ms. Brazo has filed a motion asking that I reduce the bond in the murder case. And while we're here, we obviously need to talk about a bond being set in the MTRP case as well. And so the bond in the murder new indictment is set at $1.5 million, and then there's no bond in that MTRP. Is that correct?
That's correct.
All right, are you, Mr. McCrae, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Ms. Brazo, you may proceed.
Would you state your name for the record?
Right.
And we're here today on the motion to reduce your bond that's currently set at 1.5 million to $50,000. Is that correct?
Yes, ma'am.
If the court were to reduce your bond, do you have any assets that you could sell to make money to possibly make your bond? Do you have any means of making that bond that were reduced to $50,000?
Possibly.
Okay, could you explain?
Like just a car, like I was just renting things like that. So personally, I don't like own a house or anything like that. I do it on my.
Speak up. I'm sorry.
Oh,
I
excuse
have
me.
to hear you, and so does the
Sorry.
court
I
reporter.
don't own a house or anything. I was renting, but I do own my car.
Do you have?
So that'd be my own means,
Okay.
and then my other assets like clothes and stuff like that. So
What about family members? Do you have any family members that could potentially help you
that's
post your bond?
that's a good possibility.
And are you asking the court if you are placed, if the court does reduce your bond, that you be placed on house arrest or have a GPS tracking device that would only allow you to leave your house for meetings with me, your attorney, or medical purposes?
Yes, ma'am.
Where would you be residing? That relates to my bond. If that were to happen. Where would you reside?
More likely, I have to check with my sister.
Is that the only place that you would have to go?
No, now, but I know, friend, I know he's real busy. They both stay in Houston. So technically right now, I can check with some other family members. I know they all work and everything, and I have to talk to them first. I just can't say yes and voice into their on welcome.
Now, these family members, are they within Jefferson County?
Yes.
And who are the family members?
Sisters.
So you have a sister that is here locally?
Yes, and I have them in Dallas.
Okay, what is your sister's name?
With-
That's here locally.
Oh, there's a couple of them, but Michelle.
Shh. I'm having a really hard time
Michelle?
hearing.
Yes, that's one of them.
Thank you.
And what is, do you know her last name?
His name is mine.
Okay, I was just making sure. Where does she, do you happen to know her address?
I just know she's staying in the West End.
Have you been in contact with her recently?
I talked to her when I got here. My father passed. Haven't really spent too much time on the phone unless it was like with my good friend. You know, I ain't really had much money to put on the phone. So, I was still in TRP phase, so it was really nothing for me to keep in contact with.
Okay, that's all I have, Your Honor.
Any questions of the witness, Mr. Smith?
No, Judge.
Any other witnesses with regard to the bonds?
No, Your Honor.
I am, for the record, taking a look at the probable cause affidavit and the new case. So give me just a second to go through that. Mr. Smith, what is the state's position with regard to bond in each of the cases?
I believe that the bond in the murder case is not set too high, and I believe that he is entitled to a bond in the MTRP because it's a deferred probation. But we would ask that a high bond be set in that. I believe we will be seeking to stack these cases, punishment in those cases. So we believe that he will be in prison for a significant period of time. After he committed the murder, he did flee the jurisdiction and was located in Houston.
Do you know how long that was from the time?
It was, I don't remember, it was several days or more.
Give me just a second. I'm looking back now at the previous pre-sentence report, so just to get an idea of what the underlying,
Excuse me, I know.
hang on just a second. I'm on that.
If you recall, Judge, this is the case, we were in trial on the sexual assault, and the state had rested. And when the state rested, the defense wanted to recall the victim,
Yes,
and the victim we were unable to locate to bring back.
okay,
And so that was the reason that he pled to the aggravated assault rather than was sentenced by the jury to the sexual assault.
got you.
Your Honor, if I can allow Mr. McCrae to respond to the fact that, or to the statement that he was in Houston. If I may.
Sure.
Okay.
I was never in Houston. I never left this jurisdiction. I was found at my ex's house the next day. I never left.
And on Euclid.
Yes, I never left.
Okay,
So for me to flee, never left.
And that is correct, Your Honor. He was arrested at Euclid, and there was some steps that were taken after that to search the residence,
Right.
and so forth. But it's my understanding from that point, which was either the next day or within a few days, he was apprehended there.
okay. I think you have some misinformation on that maybe, or,
There was some info, I don't have the file with me, Judge. I just remember reading that they had suspected that he had been in Houston.
okay,
But now that I think about it, we have found the motorcycle that was used in the murder.
There's no more.
You're thinking of,
Different.
you're thinking of a different case.
It was a one.
That's the other case I've got cited. I apologize.
Yeah.
I'm getting confused.
Okay.
Do you have your file in this case?
I don't have it down here. It's upstairs.
Okay, so. On the offense date, okay.
Your Honor, also, if I may allow Mr. McCrae to speak about, since the underlying offense for him being placed on deferred adjudication, there were some allegations made as to what happened that he would like the court to be aware of. And I wasn't part of that.
That's all
case,
done
so I
on
just-
probation
okay.
for it, entered a plea of guilty to the aggravated assault. I was there, listened to
Okay.
the trial. I don't need any other information on that. So in cause number 21-38-55959, I'm sorry. Which is the motion to revoke unadjudicated probation. I'm going to set the bond in that case at $400,000. Condition of that bond, if made, is that Mr. McCrae would be on house arrest with a GPS monitoring device. I'd obviously have to have an address locally where he would be. And then in cause number 26 DCCR 0399, I'm going to I'm going to grant the motion to reduce the bond. I'm going to reduce the bond in 2060 CCR 0399 to $1 million. Condition of that bond also, if made. A condition of that bond, if made also, is that you will be required to be on house arrest, wear a GPS monitoring device. We'll get the case set for an announcement, obviously, make sure, I'm sure there's a lot of discovery. Has all of that already been turned over? Is there anything missing?
I believe that we have received everything. I'm in the process of reviewing it. It's quite voluminous. So,
All right.
if
So-
something comes up, I'll let the court know.
All right, Mr. McCrae, I'm sure Ms. Prazo will be out there to start going over the discovery with you so that we can see about getting an announcement which way your case will go at the next court date. All right, you can go back with the bailiff.
Thank you.
Are you Kevin Lee Tran?
Yes, yes. Ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictments and the motions?
He does, Judge.
Mr. Tran. In clause number 25 DCCR 0423, you're charged with the second-degree felony offense of assault on a peace officer from March 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
This was in there. And are you pleading guilty because you actually did what they charged you with? Sorry.
Yes.
And then in clause number 25 DCCR 0424, you're charged with the third-degree felony offense of assault on EMS personnel from March 14th of 2025. And how do you plead to that charge?
No contest.
Is it you're either guilty or not guilty? And are you pleading guilty freely and voluntarily?
No.
And because you did what they charged you with? In those two cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Speak up, please.
Yes.
And Your Honor, I would ask the court to take judicial notice of the letter dated March 12, 2026. Should have thrown it in at the first.
In what case?
All of these cases, Your Honor,
Okay, hold on.
Mr. Tran had been evaluated, was incompetent for.
Oh, hold on. Okay. Hold on. Thank you, Mr. Nicholas.
Yes, Your Honor, I should have done it at the onset, sorry.
Sorry, they're not in together. Okay, here we go. It's okay. I know. I just have to say it out loud. All right, I'm going to take judicial notice also in all of the court's files. And hold on a second. Mr. Tran was evaluated for competency and was found not competent to stand trial back in August of last year, was sent to the John Dunn Behavioral Science Center for competency restoration, received the report from them dated March 12th of 2026 that has the finding that Mr. Tran has attained competency and is currently competent to stand trial. Is there any other evidence with regard to competency?
Not from defense, Judge.
Not from the state, Your Honor.
Okay. Then at this time, based on that report, I will find that Mr. Tran is competent to stand trial. So now I gotta go, where was I? All right, so I went through clause number 0423 and 0424. And so, Mr. Tran, did you go over the paperwork on the tablet with Mr. Lewis?
Yes, Your Honor.
And you fully understand it?
Yes.
And you understand, if I follow the agreements that you've made with the district attorney, that you're waiving your right to appeal?
Yes, Your Honor.
State tenders number one in each case.
No objection, Judge.
They're admitted in each case. Again, I'm going to find that Mr. Tran is competent to stand trial. Mr. Tran, I'm going to find that you entered your pleas of guilty in each of these cases freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 25 DCCR 0423 finds you guilty of assault on a peace officer, sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 25 DCCR 0424 find sufficient evidence to find you guilty, and at this time finds you guilty of assault on EMS personnel, sentence you in accordance with that agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-37560, I have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the state jail felony offense of theft of property. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, Your Honor.
And Judge, count one is one of the offenses we just pled to. Count two is one that's being dismissed. We could just do count one of these. That's all right with the court.
1 and 3.
Yes, Your Honor.
Just a second. And then in cause number 21-38780, I also have a motion to revoke your community supervision. This shows that you were placed on probation February 16th of 2022 for the 3rd-degree felony offense of assault family violence by impeding breath or circulation. And that was a 5-year term in prison that was probated for 5 years. Is that also correct?
Yes, Your Honor.
These cases each allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of assault on an EMS personnel, the one that we just went through, from March 14th of 2025. And is that true or not true?
Yes, it's true.
And then count 3 in each case alleges that you committed the new offense of assault on a peace officer from March 14th of 2025, also the other case that we just went through. And is that true or not true?
Yes, Your Honor, it's true.
Did you enter your pleas of true in each of these cases to counts 1 and 3 freely and voluntarily?
Yes, yes,
And did you plead true to those counts because those counts are actually true?
yes,
In each of those cases, I also have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
yes.
And do
Yes,
you
ma'am.
fully understand them?
Yes, Your Honor.
And again, you understand if I follow these agreements that you'll be waiving or giving up any right to appeal.
Yes, Your Honor.
State tenders number 1 in each of these cases.
No objection.
It's admitted in each of those cases. All right, Mr. Tran, in each of these cases, in cause numbers 21-37560 and 21-38780, I'm going to find that you enter your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true. And 21-37560, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 21-38780, find sufficient evidence to revoke your probation. And at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. All 4 of these cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in all 4 cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. I have just signed a dismissal in cause number 25 DCCR 0422 as part of that agreement as well. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.